Joe Zarzaur here with another installment of Zarzaur Law TV. I'm going to talk about social media for a second. Social media and plaintiff personal injury litigation really don't go well with each other. And I think this is more of a PSA, not necessarily for people involved in personal injury cases, because by the time you get involved with a personal injury case and you're in the office here, it's almost too late for you to go back and fix the social media issues that I'm going to talk about. But here's the deal. Facebook, let's just talk about Facebook. Facebook is, people think that the direct messages on Facebook are private or that their posts are private so long as the privacy settings are correct. But in actuality, Facebook as a whole, even the direct personal messages that you send between Facebook members are not private. In fact, they're public. And so here's how it works out for you. If you share a lot of stuff on Facebook and you end up being involved in a personal injury case, your entire Facebook database, all of the information you put on Facebook, whether it's the private messages or direct messages or your timeline or whatever, all of that is downloaded in the case. And even if you were to delete it, the deleted material would show up, and then it would show that you deleted it on a certain date. So there's no getting rid of it. And the reason that's important is that people end up in these cases and they may have done some things way back 5, 6, 7 years ago on Facebook that they're not proud of, and they end up here in the office, and we have to, as part of the case, if we end up in a case, they always ask for your Facebook page. And we fight about it sometimes, but most of the time the judges are going to give the plaintiff's Facebook account pretty much in total to the other side. So what happens is they end up producing a lot of things that people felt like were private and personal, especially the direct messages. And it turns out, you know, in the case, the clients are surprised to know they have to turn it over. So I think this is my way of saying to you folks that use Facebook, if you're going to write something really personal or going to send a picture that's really private and personal, you probably shouldn't use Facebook. You probably should just do that via text or maybe another social media thing like Snapchat that actually doesn't keep a record and can't be downloaded. But the idea that Facebook is private is just not the case. Facebook is not private. The private messages, direct messages on Facebook are not something that you can delete and hopefully destroy forever. They're there forever. So just so you know, it's not going anywhere. Your timeline posts are not going anywhere. I've given other videos on how you should treat a Facebook account after you become a client, and you might want to look at that video because you're basically going to be looked at through a microscope after you become a plaintiff, so you should be careful what you put on Facebook and other social media that can be discovered. But for purposes of this discussion, just understand that the direct messages and private messages on Facebook are not private. They are anything but that. So be careful what you post on Facebook and specifically what you share via direct message on Facebook. Take care. You can find us on the web at zarzaurlaw.com, and you can find us by phone at 855-HIREJOE. Thank you.